Good evening. Good evening, students. I am Advocate Alexander Mathai Paikide. I would be here to teach you for an interactive session on learn how to draft a legal notice. Now, introducing myself, I'm a legal associate at the New Delhi office of Paikide and Paikide Lawyers and enrolled as an advocate before the Bar Council of Delhi. I'm also part of the dispute resolution team practicing before various Indian courts, including the Supreme Court of India and various high courts. I have a keen interest in investment arbitration apart from international commercial arbitration. At the age of 24, I am the youngest fellow in India of the Chartered Institute of Arbitrators, London. I have received appointment as a sole arbitrator for 13 NBFC arbitrations. My field of practice consists of arbitration, corporate law, constitutional matters, civil, and taxation. I've been an arbitrator for various international competitions such as the WIS East Moot, Williams C. WIS International Commercial Arbitration Moot, and the Foreign Direct Investment International Arbitration Moot. Now, this session has been divided into 6 sections, which is first, what is notice? Second is the forms of notice. Third is the mode of service of notice. Fourth is drafting of a legal notice. Fifth is drafting reply of a legal notice. And sixth is specimen copies. Now, what is a notice? Notice means making something known to a person of which he, she, or the others was or might be ignorant. A notice can be either oral or in writing. However, a notice should preferably be in writing because a written notice is easy to prove and its contents are certain. A party sends a legal notice to communicate his grievances and to seek appropriate remedies from the receiver of the notice. It is also an opportunity to the receiver to take appropriate action to address the grievances set out in the notice, to resolve the issue cordially and thus to avoid litigation. Now, forms of notice. Now, 5 types of notice. First is a statutory notice, which has been divided into mandatory notice and directory notice. Second is a public notice. Third is a personal or private notice. Fourth is actual notice. And fifth is constructive notice. Now, what is a statutory notice? A statutory notice is when a statute or an enactment requires sending a notice as a condition precedent to institution of a legal proceeding, such as notice, is called a statutory notice. Now, that has been divided into 2 parts, that is mandatory or obligatory notice, and second is directory or recommendatory notice. Now, what is a mandatory notice? All mandatory notices are statutory. However, all statutory notices are not mandatory. Where a party who is under an obligation to comply with the provisions regarding mandatory notices fail to comply, then a legal action initiated by such party also fails. In such matters, mandatory notices are sent. Now, an illustration for the same are a notice under Section 80 of the CPC, a notice under 138 of the Negotiable Instruments Act, a notice under Section 106 of the Indian Railway Act, a notice under Section 10 of the Indian Carriers Act, etc. Now, going on to the second part, that is the directory notice. As the term indicates, such a notice is directory in nature. If the party under obligation fail to comply with the same, then consequences of such non-compliance are detrimental to the interest of such party. Directory notices is not a condition precedent by taking a legal action by the party. Now, following the illustrations, a notice of revocation or of an agency is defined under Section 206 of the Indian Contracts Act, or a notice under 131 of the Transfer of Properties Act of 1882. Such notices can be called as directory notice. Now, moving on to the public notice. A public notice is all the notices which are issued regarding the matters in which the members of the general public are likely to be or expected to be affected by are called public notices. The Black's Law Dictionary defines public notices as notice given to the public generally or to the entire community or all who to be may be concerned. Such a notice are commonly published in a newspaper or in journalist circulation. Such public notices can also be found in government gazettes. It is pertinent to note that as far as public notices are concerned, newspapers have the wide circulation. Now, examples of the same can be a notice of sale or purchase of immovable property, a notice of auction of property, a notice of dissolution of a partnership firm, or a notice of termination of an agent's authority. We can also see that in under section 30 clause 5 of the Indian Partnership Act of 1932, wherein there's a requirement of a public notice by a partner for attainment of majority rights. Now, there's also one more in Partnership Act under section 45 clause 1, which says to give a public notice prior to a dissolution of a partnership. Now, moving on to personal and private notice. Personal and private notice is nothing but notices that are addressed directly to a party who are either committed some breach or is likely to be affected. The Black's Law Dictionary defines personal notices as communication of notice orally or in writing according to the circumstances, directly to the person affected or to be charged, as distinguished from constructive or implied notice, and also from a notice imputed to him because given to his agent or representative. Example, notice to appoint an arbitrator, notice by a landlord calling upon tenant to quit, and so forth. Now, actual notice. An actual notice is, as it said, is actual and expressed. When a notice of any fact is given to a person either orally or in writing. Actual notice may be either expressed or implied. In the one, it is established by direct evidence. In the other, by proof or circumstances by which it is inferred as a fact. Black's Law Dictionary says that notice expressed or actually given or brought home to the party directly. According to law lexicon, actual notice is when there is a positive information of a fact. Now, constructive notice. When due to existence of a certain facts or circumstances, it is presumed by law that a person has notice of those facts, it is termed as constructive notice. Now, law lexicon defines constructive notice as follows: legal inference from established facts, notice imputed by law to a person not having actual knowledge, knowledge of any fact which would put a prudent man upon inquiry. For example, a registered deed, a pending lawsuit, and so forth. Now, modes of service of a notice. There are 5 modes of services of a notice. First is a personal service, service through post, statutory prescribed mode of service, service by implication, special mode of service. Now, in-person service, the notice is served to the addressee personally. The service of notice by registered post acknowledgement due, that is RPAD, is one of the convenient and safer mode of services, as one can prove the fact of service of notice. Also, law will presume that a notice was being sent by a registered post, which was relatively duly served, as per section 114 of the Evidence Act and section 27 of the General Clauses Act. Now, where a statute prescribes a particular mode or of a manner of service of notice, then the prescribed mode of service has to be followed. For example, a notice under section 80 of the CPC, directing the notice to be delivered to or left at the office of a secretary to the union or provisional government. Now, contractual mode of service. This mode, which is agreed to be concerned party, must be followed, example in arbitration, partnership, contracts, and so forth. The notice should be served conforming to such mode. The indirect mode or service by implication arises when the notice giver sends the notice through a barrier or special messenger or through by post, but the addressee refuses to accept it. When this addressee refuses to accept the notice is presumed to have been served by implication. And lastly, leaving of a notice to a part of a premises of an addressee in an illustration of a special mode of service. Example, when a person is not available at the apartment, then the neighbor of the person is being given the notice. Now, before we go to the drafting of the legal notice, does any of the students have any doubt on what have been taught about?
So if you could repeat the actual notice part back then.
Sure. So actual notice is actually a notice given to be in actual or is expressed. That is when the notice of any fact to a person is either orally or in writing. Actual notices are either expressed or implied. That is a direct evidence. Example, a normal, let's say a regular notice, which say, if you say that you have taken some money from a friend of yours and you want to write a notice to him. Now you can write it easily saying that you have owed so and so money and therefore you could ask them back. That could be an actual notice. Is it clear or should I go more forward?
Yes, sir, it's clear.
Okay, thank you. Now, in this regard, I'll be giving you certain tips first of how to draft a legal notice, since these would be the primary ingredient for drafting a legal notice. Firstly, a notice is a foundation of any legal action, proceedings, therefore, utmost care should be taken while drafting a notice. A draftman should draft first, obtaining complete information of facts and transactions regarding such a notice to be drafted. Please do not draft a legal notice with half information. Thirdly, a draftman, after securing information, must then work on the legal issues which should be addressed. For example, whether the contract is void or voidable, whether any right is violated, whether the client is entitled to damages, etc. So, therefore, legal issues must be addressed carefully. Fourth, understand the need and requirement of the client. Please note that the sample format of a notice is not sufficient to draft one. You should always address the needs and the requirements of the client while drafting the notice. Focus on the objective which the client or the party desires, because otherwise your notice won't stand out and might miss out a key ingredients that can be addressed while in litigation. Now, fifthly, arrange the facts in a chronological order and in a numbered paragraph. The reason why I said numbered paragraphs is because while you are in court of law and the said notice is brought to the judge for evidence purposes, the judge will ask where in the notice have you addressed particular issue. If you have the para number, it is easy for the judges to know and easy for you to address them in the written pleadings. Now, every notice must state the name and the full description of the sender of the notice, whichever notice it might be. The name and full description of the sender is a key ingredient. It must state the name and the full description of the person to whom the notice is given, the addressee or the receiver. So it should also have the clarity in this aspect too. Now, a notice should also state and give reasonable time to the opposite party to comply with the demands made in the notice. Certain notices, as told above, are statutory notices. Statutory notices require you to wait for 2 weeks to 30 days to sometimes 2 months. So therefore, you should always give the opposite party reasonable time for them to comply or to give a reply. Now, the object of a notice should be clear, directing the party to comply with or to refrain from doing certain things or act. Now, example, now you're asking a friend of yours to give you money. So it should be a compliance. Or example, if you're asking your neighbor not to build a wall because it's trespassing into your land, that's why it's referring the neighbor to build a certain wall. Now, a notice must be signed by or on behalf of the sender. Example, the advocate when the notice is sent through him. So every single notice must be signed. A signature in a legal document is very essential, since you might all know. But since if you're an advocate, you should specifically say that you're advocate representing the client, whoever it is. Now, the notice must have these three things. That is, state the date, place, and the mode of service of notice. The reason why, because if there was an incident that happened with me, not with me, but I came to know about it, that the date. So one of my friends sent a legal notice in which he signed the legal notice and wrote the date under the signature. Now that was disputed since they do not know the correct date on which the legal notice was sent. They said the date of signature would be held, but then they said no, it should be after that. So remember, date of the notice must be clearly written. The place also has significance because in certain contractual obligations, the place of dispute or the jurisdiction can be decided upon the place on which the notice has been sent. The mode of service, that is also important since it can be sent by registered post acknowledgement due or via courier or speed post or any other mode that you specify. But that mode of service must be written clearly on the notice. If the notice is required by law, it is to be given within a certain frame of time, and those details must be stated in the notice. Example, in the a legal notice under Section 138 of the Negotiable Instruments Act. The Act specifies a certain a time frame that must be followed by the advocate or the person who's making the legal notice. Now, is students clear with these, or should I address certain points?
Yes, sir, it is clear.
Okay. Now, these are my personal views that I find always whenever I draft any legal notices. These are the three key ingredients that I always remember whenever I'm drafting a legal notice. That is, it should be simple, it should be precise, and it should be concise. Just because there's no time page limit to a legal notice doesn't mean that it can run to 5 to 10 pages. It's a good practice that it can be limited to 1 page or maximum 2. More than that, if required, then sure. Otherwise, if possible, to limit it to 1 to 2 pages. Be precise. Just because you have facts at hand doesn't mean that you have to spread out all the facts in the legal notice. You could only select the facts that is required for legal notice and address them. Concise is because the more you write, the more the person will get confused. So be concise, be small. Do not write, if you can write a 10 lines to 2 lines, that's much better always. Now learn from mistakes. There is no perfect way to draft a legal notice, but it doesn't mean that you won't make mistakes. So drafting helps you become a better draftman. So make more mistakes and learn from them. There is no perfect format. Please remember that you might find formats from internet, from books, or from while going through pleadings. Please remember that cannot be termed as the perfect format. Everyone has their different, but there are key ingredients that is required for a legal notice. Be creative. Be creative as much as you want, but do not disturb the essential ingredients or the requirements of a legal notice. Now, while drafting the notice, the reply notice, now that is also a very key ingredient since making the notice is easy, but you should always draft a notice thinking what the reply could be. But while you're replying, you should also follow these steps. Every notice received should be replied to as promptly as possible. The avoidments in the notice which are incorrect or fabricated should generally or specifically denied. And then the facts and objects on behalf of the addressee or the receiver should be stated. In notice reply, while making denials, reference should be made to relevant documents, correspondence, etc., based on which the denials are made. Notice reply is basically a written statement or reply to the complaint or proceedings. Therefore, it is required to be drafted very carefully. Finally, please note that the notice should be also sent in the mode of service which is easily proved. Example, RPAD, uh, that is registered post, acknowledged due, or via courier. Now, specific copies. I'll be showing certain draft like legal notice copies, so for you to review. Yes. So this is a notice of dishonoring a check. As you can see, from address, date, to. Here there'll be mostly the place from which the notice has been sent. Now, sir, madam, whoever it is to, it should be said under the instruction so and so. My client carries the business of so and so for so many years. These can all be edited and be changed to the requirements of your client. It can say that the check was being issued for so and so amount in the favor of my client, dated bearing number so and so, drawn out from this bank. State that for why it has been done so and so, all the requirements has to be given. You can say that my client has stated all of them while the check was presented was dishonored. You can say that and everything. And later you can say my client has therefore instructed to call upon you, and I thereby do and inform you that you are called upon to pay an amount of so and so with an interest rate of so and so within 15 days of the date of receipt of this notice, failing which they will take appropriate legal action. Now, this is one format under the same, that is notice of dishonor of check. There's another format under the same, that is so and so, that my client has entered into, that as per the contract, that as per so and so, and you can see the ingredients. Now, the reason why I'm showing the same is here the person, the advocate who is drafting it has written my client states, my client states. Here in this draft, it is that my client had, that as per the contract, that against the supplier, that my client represented, that my client states. These two formats are correct, but these formats have been presented differently. So as a drafter, you have the ability or the option to be creative or to use any vocabulary to make sure that it's concise, precise, and accurate. Now, moving on to another different notice. Please wait. Defamation. So now this is a case of defamation. Now this would be a personal notice. So here you would be saying under the instructions of my client, so and so, who is so and so, what happened, what was the due, how you got to know, and you say that this is how you have harassed me, and this is what like what the client has been through, and thereby asking them to reply to it. Here, if you can see, they said that 8 days from the date of the receipt of this notice. So thereby, it's not required that you have to follow 2 weeks or 1 month, depending on if it's a statutory notice, then it has to be in complying with the time frame that is given in the statute. Otherwise, you have to give the other party sufficient time for them to reply. Uh, Moving on. So here I have almost 41 pages of different types of legal notices. There's power of attorney, there's a lot of legal notices. So the more you go, see example, this is a notice of recovery of money and appointment of an arbitrator. Especially it's very important in the cases of arbitration. Now here also you can see there's a from, then there's a date, to address, sir or madam or others, under the so and so, my client, or whatever the details is. Then you can see under which section of the contract that they have entered, which says there's a dispute resolution clause, and hence they're invoking arbitration, and thereby saying that how much is the money, what has went wrong, how many times they have tried to communicate with you, and there has been no answer, hence they are going to invoke an arbitration clause. and because of which they're going to appoint an arbitrator. An arbitrator can be appointed by a courts, or if it's an ad hoc arbitration, then it can be decided by the parties. Also, it can be also being given to an institution to adjudicate or to conduct the arbitration, and so forth. Now, as you see, an arbitration's notice is almost 4.5 pages. So there's no concise limit to how many pages a legal notice can be, but it is advised that it's limited to 1 to 2 pages. But depending on the legal premises of the legal notice, it can extend to how many pages you want. So this is notice of eviction. Even this is a permanent legal notice that you as an advocate will be sending across, wherein you will be saying the tenants under so and so lease or rent deed that they have gone through. Now they want you to evict the certain place. You will say the place name, the details, everything. Then you'll say you're giving them a month or 2 months or 3 months for them to evacuate, and therefore, and you will set out that the said notice is terminating the tenancy agreement and so forth. So these are certain specimen copies, and thereby this is. So thank you everyone and have a nice day. If you have any questions, please feel free to ask. Do you students have any questions?
No, sir, it was very insightful. Got to learn from it, and yeah, that's it.
Okay. Do you students have any questions regarding arbitration or international commercial arbitration? Please feel free to ask me if you have any.
No.
Do you students have any questions regarding legal notices or what you found while you were interning or any other places? Okay, students, it was a great experience for me to impart some information of practice from my side. I still remember my law school days, and I feel and understand how much tiring it might be for you to sit in the evening to attend these classes. But anyway, thank you for this opportunity from Law Internships. If there is anything that I require to do, please do let me know.
Thank you, sir.
Thank you. Thank you, everyone. All the best.
Thank you so much, sir.
Thank you.
Thank you, sir. On behalf of Team Law Internships, would like to extend my heartfelt gratitude to Advocate Alexander Mathai Paikade, sir, for taking out time from his busy schedule and interacting with young minds. It was truly an enriching session. Thank you, sir, for sharing such wonderful knowledge and experience with us.
Thank you.
Thank you, sir.
Thank you, sir.
Thank you.